Let's get straight to our newsmaker this evening, Congress MP Manish Tewari. He's joining us to speak on three big legal tangles India is debating today. Sacking of the Tamil Nadu minister, Balaji Senthil, by the governor. Many people have called it an overreach, and a constitutional overreach. Then there's also the matter of the UCC and Manipur. Rahul Gandhi has finished his trip to Manipur. Mr. Manish Tewari, good evening. Thank you for your time. I want to ask you why you say the President of India should sack the governor of Tamil Nadu. What's the grave crime that the governor has committed that he needs to be sacked?
The grave crime that he has committed is that he is ignorant of the Constitution of India. He has flagrantly transgressed the constitutional scheme. Article 164(1) of the Constitution is absolutely clear. Ministers are appointed on the recommendation of the Chief Minister. That ipso facto implies that ministers can only be dismissed or removed or their resignations accepted were the Chief Minister to so recommend. For the governor to take unilateral action in dismissing the Chief Minister is either a flagrant act of arbitrary high-handedness, it is capricious in nature, or it is ignorance of the Constitution. So therefore, under any circumstances, someone who does not understand the letter, the spirit, and the essence of the Constitution has no right to continue as a governor.
You speak of Article 164. Doesn't Article 164, the same article, also say that ministers shall hold office at the pleasure of the governor?
Well, if the governor does not understand that the pleasure cannot be exercised without a recommendation from the Chief Minister, then I am afraid the governor possibly does not understand the essence of that constitutional article. The pleasure is not discretionary. If that pleasure would be discretionary, then governors would be hiring and firing ministers all across the length and breadth of this country. And so therefore, where does that leave your parliamentary democracy? A person is elected as a member of the Legislative Assembly. If his party comes into power, which is that they have a majority in the assembly, then the governor invites the leader of that party to be the chief minister. On the recommendation of the chief minister, then ministers are sworn into the state cabinet. And therefore, if a minister has to be dropped from the state cabinet, it can only be done on the recommendation of the chief minister. This is not rocket science. The constitutional scheme never contemplated a role for the governor where he can hire and fire ministers at his will. If you were to extend this logic further, then the governor can also fire the chief minister because he's one more minister. He's just first among equals. So did our constitutional scheme envisage or contemplate that?
Mr. Tewari, if you look at the contents of the letter that the governor, RN Ravi, has written to the Chief Minister MK Stalin, he says this guy, Senthil Balaji, has been accused of corruption. He's under arrest. He continues to be a minister, which is why he's in a position to hamper investigations. Therefore, it is absolutely necessary that he needs to be sacked. In that sense, would you say that the governor's logic holds?
His logic is completely warped for the simple reason, and what surprises me even more, is that the governor is a former police officer. When he must have entered the portals of the police academy, the first thing he would have been taught is that Indian criminal jurisprudence mandates that you are innocent until proven guilty, and proven guilty by a court of law, not by the whims and fancies of a governor. What is a first information report? It's just a first information report. Or for that matter, what is a charge sheet? A charge sheet is at best an appreciation of facts and events as understood by the investigating officer. It has no more locus in law. So therefore, which court has convicted Mr. Senthil Kumar? That the governor decided to exercise discretion and discretion which he never had, misplaced discretion, in order to sack the minister. So therefore, in fact, that makes it worse. If it would have been somebody who was ignorant of the constitution, ignorant of the law, it could have been still understandable that he was shooting from the hip. But here you have somebody who spent a lifetime in the Indian police service, must have at some point in time served in some thana, done some bit of investigation, prosecuted those cases in a court of law, and therefore he or she understands that an FIR or a source information report or an ECIR, as what the Enforcement Directorate calls it, is nothing more than a complaint. And if you actually look at it, there is a question of mine in Parliament. You can possibly find it on PRS. These agencies, which are nothing but tools of political persecution, what is their track record of conviction? Abysmal. If you compare the number of ECIRs which have been registered to the number of convictions which have been secured in the last 9 years, it is laughable. In fact, there's a very, very serious case. It's unfortunate that the Supreme Court decided to uphold some of the draconian amendments to the PMLA. But I think a new government in 2024 must either repeal PMLA or at least review it in order to prevent its gross and blatant misuse.
But Mr. Tewari, and this is my last question to you on the subject, there's something called propriety in public life. The investigation against Mr. Senthil is currently underway. It's happening under the directions of the Supreme Court. Won't it be the right thing to do, the correct thing to do, to ask Mr. Balaji to step down, at least till the investigations are over?
Well, ma'am, propriety in an age where political persecution and vendetta is the norm and not the exception is possibly a wrong question to ask.
Okay. In that case, let me ask you the right question. Can I get a reaction on how the Manipur administration has handled Rahul Gandhi's visit? How do you see it?
Well, first of all, I am absolutely anguished that the Prime Minister has not spoken a single word on money. Not a single word of support. Not a single word to apply the healing touch. Not a single word to apply the soothing balm of comfort on a state which has been torn asunder by ethnic violence. 12,000 odd people are in relief camps in the neighboring state of Mizoram. Manipur is a border state. It has serious law and order implications. So therefore, under those circumstances, it was left to the leader of the opposition or the former Congress president to go and apply that balm of succor and to try and heal the wounds. And there also, rather than facilitate the visit, take advantage of it. After all, he's doing a national service. You decide to subvert that visit also.
But the BJP says it's Rahul Gandhi who's taking advantage of the situation. They're calling him a political opportunist who's no masiha of peace. Instead, he wants to keep the pot boiling in the state. This is the version coming in from the BJP. If the situation is still tense there, why go there? It's a photo op, nothing else, is what the BJP says.
Well, you had 2 months to go and apply the balm of succor. Why didn't you go? What stopped the BJP from going? Except for the Home Minister, who made one visit, which unfortunately also did not calm things down, which BJP leader has gone. So therefore, to talk drivel all the time and try and undermine those who seek to bring about peace and calm in the state of Manipur, bridge the divide and the gap, which unfortunately has come between communities who have been living in peace and harmony, is nothing short of doing national disservice.
Can we just shift our focus for a brief while now to the UCC? You're a lawyer of the Supreme Court as well, and this is something that is going to reach the doorstep of the courts as and when it comes into being. The Prime Minister for the first time, I think, has spoken publicly about the UCC. Do you think that the time has come?
Well, the Article 44 of the Constitution of India is aspirational in character. It's a directive principle of state policy. It is not mandatory. Had it been mandatory, it would have been a part of the fundamental rights. So neither is the directive principles of state policy, nor is our fundamental duties mandatory. Number two, in a country where you celebrate diversity, where is this uniformity, or how is this uniformity going to strengthen your internal cohesion as a society? I represent a constituency where the Khalsa Panth was founded. Sri Guru Gobind Singh Ji Maharaj, on the 13th April 1699, founded the Khalsa Panth. I would like to ask the government, if you have a uniform civil code, where does that leave the Akhand Marriage Act, under which the Sikh marriages are solemnized, which has been passed by Parliament? And in any case, in the Hindu faith itself, there are a myriad ways in which marriages are solemnized, succession and inheritance happens. In any case, in the Indian legal pantheon, there is already a self-contained uniform civil code. That is the Special Marriages Act and the Indian Succession Act. So therefore, if somebody wants to subscribe to a uniform civil code, all that he needs to do is get married under the Special Marriages Act, like I did, and you are governed then by a secular, a religious agnostic, marriage law, and the sequel to that is the Indian Succession Act. So there is already a uniform civil code in the Indian law.
But one of the arguments that is being made by people who are supporting the Uniform Civil Code is that what is the harm? And more than anything else, this is about gender justice. This is about, women getting, Catholic women, for example, getting divorces more easily, polygamy being banned, something which is a major tool of harassment for Muslim women. That more than anything else, you have to look at UCC from the prism of gender justice.
Any reform in personal laws should be an impulse which should come from within those communities. I do not see any support for the Uniform Civil Code beyond certain people in the BJP talking about it ad nauseum. As I said, if you study the Hindu Marriage Act, you study the Hindu Succession Act, or you study the Maintenance Act, right? There is, as I said, there is so much of diversity within that. You cannot even bring uniformity out there. What to talk about bringing uniformity inter-see religions? And if you want to talk about secular, non-agnostic parts of the law, you have 125 of the Civil Procedure Code, which governs maintenance, right? I talked about the Indian Succession Act and the Special Marriages Act 1954 earlier. So therefore, if you actually were to take these three together, the Special Marriages Act, the Indian Succession Act, and 125 of the CPC, which governs maintenance, you have a uniform civil code already.
Okay. I'm not sure the BJP sees it that way, but thank you very much, Mr. Manish Tewari, for joining us on the broadcast. Good to have you on the show. With that, it's a wrap from me, but news and updates continue right here. Do stay with us.